some of you know, but I'll tell those who don't. I'm Cy Young. I'm a former teacher, administrator. I've done all kinds of things, and I'm glad to be here, glad to see you here.
Good morning. My name is Jerry Thompson, and I'm on the leadership staff of Senator Tom Daschle. He's the Democratic leader in the U.S. Senate.
I'm Henry Woods. I'm a retired U.S. Senate staffer. In my 25 years on Capitol Hill, I worked for 3 senators from my state, the great state of Arkansas. I'm currently on a sabbatical living in Key West, Florida.
We would also like to introduce ourselves. My name is Nishant Mehra.
Hi, I'm Alina Chaudhary.
Hi, I'm Paul Levine.
Hi, I'm Allison Ng.
My name is Matthew Horowitz.
And behind us is our teacher, Mr. John Kelma.
Congratulations. We are in Unit 3, Question 3. Do we all agree?
Yes, sir.
In Federalist 81, Alexander Hamilton argued that the authority of judicial review can be deduced from the general theory of limited constitution. Do you believe his deduction is correct? Why or why not? What specific provisions of the Constitution provide the basis for judicial review? Does Chief Justice John Marshall's statement that it is emphatically the provenance and duty of the Judicial Department to say what the law is mean that representatives of the other 2 branches of the government do not have the authority to interpret the meaning of the Constitution? Why and why not? And you may begin.
As Alexander Hamilton stated, the authority of judicial review can be deduced from the theory of a limited constitution. In Federalist 78, Hamilton defined a limited constitution as one which contains certain specified exceptions to the legislative authority, and thus our political system is one of checks and balances, where no one branch can gain too much power over another. Speaking to this at the Constitutional Convention, James Madison stated, "Experience in all the states has evinced a powerful tendency in the legislature to absorb all power into its vortex. This was the real source of danger to the American constitutions. Consequently, as Hamilton stated, the judicial branch was designed to be an intermediate body between the people and the legislature in order to keep the latter within the limits assigned to its authority."
While we all agree to this function of the courts, I believe that Hamilton was incorrect in his assumption. As Leonard W. Levy argues, the legitimacy of judicial review rests on history, not on the words of the Constitution or the framers during the 1787 to 1789 period. In addition to Mr. Levy's analysis, Dean Trickett writes in the American Law Review that the courts do not owe the power of judicial review to the intentions of the makers of the Constitution, but to their own desires. Another major flaw that Levy finds in Hamilton's assertion is that evidence is so sparing. If judicial review was a normal function of the courts at the time, one might expect to find a considerable number of precedents in which legislation was invalidated on grounds repugnant to some higher law. The entire colonial period is about one single precedent.
The power of judicial review is not clearly granted in the Constitution, but is an implied power from the enumerated powers of the court. In 1789, Madison argued that judicial review would give the judiciary a check on congressional violations of rights. However, the power was truly established in 1803 by John Marshall's reaction to the case of Marbury v. Madison. This case emerged from the election of 1800 and the Midnight Judges. Marshall ruled the case itself out of his jurisdiction and also ruled the Judiciary Act of 1789 as unconstitutional. This case is the true historical support for judicial review, simply resulting from Marshall's response. Furthermore, Chief Justice Charles Evans Hughes notes, "We are under the Constitution, but the Constitution is what the judges say it is."
It is the duty of the judicial branch to be, as John Marshall stated, the ultimate, the supreme interpreter of the Constitution. However, this does not mean that the other branches do not have the authority to interpret the Constitution. According to Peter Odegaard, it is the function of Congress to make the laws, of the President to enforce the laws, and of the Senate and of the Supreme Court to interpret the laws. In Congress, there is the Senate Judiciary Committee, which filters the laws Congress makes. Similarly, the executive branch has the Department of Justice, which checks the laws the President enforces. The final interpretation of the law is still in the hands of the judicial branch, but that branch is not alone in interpreting the Constitution.
Further, in Article 1, Section 7 of the Constitution, the legislative branch is given the power to vote on every bill or constitutional amendment before it becomes ratified. For example, in the summers of 1995 and 1997, Congress was considering the proposed amendments to prohibit flag burning. By virtue of this power, Congress has the power to not only interpret the Constitution, but also have a direct impact on its substance. The executive veto works in a similar manner. When the principles outlined in the Constitution are contradicted, the President has the options of issuing either a direct or pocket veto. This panel is split regarding Hamilton's assertion, but we do agree that all three branches do have the power to interpret the Constitution.
Thank you.
Throughout American history, courts have used the power of judicial review to play a major role in the development of public policy. Some might call this judicial activism. What examples of use of this power can you cite, and why have they proved to be important?
Well, the right to privacy was extended through the case of Griswold versus Connecticut, which is an example of judicial activism. The right to privacy was an inferred right in the Bill of Rights, and it was created from parts of the 4th and 9th, also other amendments. And it's a combination of those, and an activist court brought that precedent to light.
And I'd like to elaborate on that case. And the reason it is so important is because it recognized that we have other rights besides those enumerated in the Constitution. They are just as important. And I'd like to remind you of Justice Douglas's opinion. And he said that the enumerated rights in the Constitution are like the moon, but then the emanations, or the penumbras, are the unenumerated rights that grow out of that, and they are just as important, and we cherish them just as much.
I would also add to that probably the most famous case of all would be Brown versus the Board of Education, in which the court interpreted the Section 1 of the 14th Amendment, in which it states, no state shall deny the right to, no state shall deny equal protection of the laws. So, and they assumed that because the separate but equal doctrine violated that, and they established that schools should be integrated in that case.
Okay, switching gears a bit. There have been major global political events that have occurred in your lifetime. The demise of the Soviet Union resulted in a great surge of democracy, particularly in Central and Eastern Europe. If you were advising these new democracies, what would you advise them about the concept of judicial review?
I think we can all learn from other countries around the world. In Great Britain, there is no power of judicial review. And in Canada, I believe, is the only country that has a system similar to ours. In France, they have a council which can enact judicial review. And before Germany was united, in West Germany, they had a system similar to ours. So I would say that judicial review is important, but we must also be aware of the fact that judicial tyranny can result from it, and that it provides extra power to one branch over the others.
Since the judicial branch is free from political influence, I would advise that the importance of judicial review would be that the Supreme Court or the judicial branch, however it may be, they would provide morality, and they would provide pure constitutionality for the people and for the government.
In conclusion, I would say that I think judicial review has served us well. I'd like to cite the time before Marshall exercised that, and we didn't have judicial review. The Federalists passed the Alien and Sedition Act, and they severely limited freedom of speech. So I think that it's very crucial and vital for this added check. It's helped to protect our rights.
Are there any major arguments against judicial review?
I think one of the most major arguments against judicial review is that it gives the judicial branch somewhat extra power over the other two branches, a social engineering of sorts, and judicial policy making. Because every time that a court rules on a case or that a law is unconstitutional, they're in essence making a policy for the country, and in that way they're engineering society, and you can have the result of a judicial tyranny.
Judge Bork, he has written immense amounts of literature on this subject, and he says that you have to be very careful when you go ahead and you give this power. In Charles Beard, in his book, he states the opposing view to judicial activism, and he says that we are appointing 9 people that the people did not choose over we have no control, and over whose destinies they are controlling us. And I think that's very important to remember. Just the fact that these 9 people have been appointed, and in that manner, we have to be careful about the powers that we're giving them.
Also, there is really no mention of judicial review anywhere in the Constitution, and there is some evidence that the framers didn't really like the policy of judicial review. It was talked about very sparingly in the constitutional conventions and was not added to the Constitution and was used very sparingly throughout the colonial period.
A measure to include that in the Constitution was defeated 4 times at the Constitutional Convention.
The fact that our justices are appointed, do you think there's anything political about their appointments? Do you think there's anything that they can maybe persuaded to do for a given party because that party happened to put them in office? Do you think there's any problem there?
Well, we have to remember that once the judges are appointed, they are appointed for life. And the fact that this was done is to prevent any lobbyists or politics from getting involved. I think that once they are in office, they may abide by the policies of the party that they ascribe to, but I don't think that politics should get involved here, and I don't think that they do. That's one of the reasons that the Supreme Court is so successful.
Go ahead.
But in the election of but in the appointment of the judges, there have been presidents who have tried to pack the court. I would give the example of FDR.
Getting a little too far. Thank you very much. We can give him a hand. I would like to have allowed you to go on, but it was going to be long. Very good.
Well, you have a lot of enthusiasm for the subject, and that's always exciting and encouraging. In answer to the one question that I asked about the emerging democracies, you almost got into a discussion of the difference between a representative democracy and a Westminster parliamentary system, which most of them are adopting. I was impressed that you brought in the examples of France and Great Britain and Germany, because having been in the position of having to deal with delegations from these countries, I know that they identify more with the parliamentary system than our system of democracy. What you didn't hit upon was that our notion of an independent judiciary is pretty foreign to them, and so you really have to make a point that independent judiciary is crucial before you can even get to judicial review. I thought I heard the statement that Marbury v. Madison was the historical support for judicial review, when in fact it was how we got judicial review. And one other thing I didn't hear in that context was that the court just took it. They weren't granted the power. You did make a point that it's not in the Constitution, but it is important, I think, to note that they just took the power. I thought your introductory statement was well-rounded, well-prepared, and hit all the major points.
I also enjoyed your discussion. I would prefer anytime you cite people who, other than framers that are well known to the general public, that you might include a phrase credentialing who they are. Levy, the dean you cited, just might be helpful for your audience as to what their credentials are that make them worthy of citation. I like the 2 examples you chose for my question on judicial activism. We could have spoken all day on that particular subject. I'm sure everybody has a favorite story to tell on that one. I thought it was very effective that you particularly mentioned a situation before Marbury versus Madison that was one of the factors that led to the acceptance of this principle, the fact that the Alien and Sedition Acts pointed up a reason why we needed to sort of blaze the trail before that. And I wish you had had time to elaborate a little more on the fact that judicial review, what actually happened in the Constitutional Convention, that it had been defeated 4 times. And I thought it might have been more effective if you had been able to cite a particular quote from one of the major players about that particular subject that might have strengthened your presentation. But overall, you've obviously done a lot of brainstorming and study of this subject. You can be proud of your representation.
And I like the fact that you do know what you're talking about, and when you do deal with your case law, which is on the other hand what my colleague was saying, you did in fact let us know what the case law was, what it was about. And that's extremely important to me. I need to know that you know that. And you did a very good job of that. We have time constraints here, so I think you put a lot of information out in the amount of time that you had, and I congratulate you for